I'm going to skip most of these slides to start with. All right. Sandy just gave a presentation, which was what is the law? What is the Consumer Credit Protection Act? I'm going to muck it up. We're not going to talk about what the law is. We're going to talk about what the law may be, may not be, and whatever it is, it may change in a year or 2 years. We just don't know. So what we're going to talk about, let me kind of go back. May 7th, 15 days ago, the Consumer Financial Protection Bureau issued, for the first time ever, a proposed rulemaking relating to the Fair Debt Collection Practices Act. It is 537 pages. A copy of it is right there. That does not include proposed disclosures. It doesn't include the addendum, and that doesn't include all the information that's cross-referenced within the proposed rulemaking. It is a lot of information to digest, even from May 7th to today. For 15 minutes, it's impossible. So what I tried to do, and Victoria too, in our presentation, was to try to divide it up into 3 big areas. And one of them we're not really going to cover in this presentation. The first one is, how in the world did we get here? What is the background? What happened with the original statute and what occurred with respect to the rulemaking? The next section is talking about the 12 key conduct proposals that are in the proposed rule. And the last part is about the 4 key disclosure proposals in the rule. And I say key, that is not my word. That is the CFPB's word. On their website, in their fast facts about this new law, they say, here are the key conduct proposals. Here are the key disclosure proposals. So if the CFPB is talking about it and calling it key, we need to pay attention, because some form of that, whether it's different or not, is going to be the law. So I initially thought I was going to do some slides on the background. Let me just talk a little bit about the background. I'm going to try to get through this a lot quicker instead of doing slides. Background, getting up to the law. That's interesting. I don't know how I did that. I'm moving that from the water. We started in 1977. Fair Debt Collection Practices Act gets passed. FDCPA has 3 underlying currents to it. 1, prevent abusive debt collection practices. Number 2, create some form of consistency with state consumer protection laws. Number 3, and I find this one a little humorous because it's always out there and it doesn't really matter, it's protect the debt collectors that are complying with the law from those who are not. So those are the 3 underlying currents. So what happened from 1977 to, say, 2010? Rulemaking? No. Regulation? No. Why not? Because in the original act, Congress did not delegate any federal regulatory agency to promulgate any rules. So there were no rules. The only thing that you had was the Federal Trade Commission coming out and giving some advisory opinions. Very limited, very spread out, and in areas that really didn't help a huge amount. You had case decisions, inconsistent case decisions, different circuits. So there goes the goal of consistency. But with respect to the new rule, the one thing that did occur in all those decades is very important. We have new modes of communication. We have email, we have texting, we have social media, and according to my kids, social media venues I've never even heard of, and they tell me I'm outdated. And then we have messaging. These were not available in 1977. They are now. So the emphasis of the proposed rulemaking really is the new technology. So we go from 1977, 2010, nothing's going on. We've got inconsistencies. 2010, we discussed earlier, Dodd-Frank. Important in this discussion for 2 reasons. 1, it creates the CFPB. We now have a central depository to go ahead and get consumer protection in one area where the rules can be consistent. Number 2, it's at CFPB. You now have the authority to promulgate rules relating to the Fair Debt Collection Practices Act. Great, maybe we're going to get some consistency among the laws. CFPB, I think it was in July of 2011. Norman, you would know better than I would, but I think that's when they open up their doors. Advanced rulemaking notice, November 2013. CFPB says we are going to have an advanced rule. We're going to promulgate one. Here are the 4 areas of concentration we're going to bring out there. 1, communications between the consumer and the debt collector, the type of communications, how it's communicated, what words are said. Number two, litigation by the debt collector, what type of litigation and when. Number three, credit reporting, and we're going to talk that in terms later on relating to passive debt buying, passive debt collection. And then disclosures, what type of disclosures? Outside of validation notice, what else do you have, including potential disclosures, Jonathan, with debts outside of the statute of limitations? They've gone through studies, through surveys, through focus groups, through the Small Business Review Board since 2013. A lot of data has been accumulated, and that has all culminated in the rulemaking, the notice of rulemaking on May 7th. So let's turn to it. I'm going to hit a couple areas. First, the expanding coverage. Maybe it's expanded, maybe it's not. Maybe it's a clarification, maybe it's new terms. I don't know, but it's different. So in respect to the proposed coverage, first thing, the definition of debt collector in the proposed rule pretty much stays the same, hasn't changed too much. It follows the FDCPA language, except when you go through the proposed rule itself, periodically you'll see a reference to, quote, consumer financial product or service. That is a term out of Dodd-Frank. It's not a term out of the FDCPA. And a reference to that usually goes to only products that are offered by financial institutions, mortgages, sometimes some auto loans, credit cards. So there are certain provisions that only relate to that. I will tell you the truth, I didn't have time to go through all that to figure out where all that is. And I don't know if it matters because it's going to change. Consumer generally, there is a general restatement, except for there's now a new interpretation that says include a deceased natural person who is obligated or allegedly obligated to pay the debt. Here's where that importance is. When you tie that in with consumer communications, you now have some clarity. Before, did the validation notice have to go to a representative of the estate or not? Could you provide information to a representative of the state relating to the debt, including even the name of the original creditor? This clarifies it. For the purposes of receiving a validation notice and for the purposes of disputing and providing information, a decedent's estate, the representative, an executor, an administrator, they're all deemed to be the consumer for that purpose. Now, how that all ties in with state probate law, I don't know. And I don't think the CFPB knows about that exact issue yet. I think we're going to find out over the next year as people put in comments. All right. I mentioned there were 12 key conduct proposals. Number one, this is a big issue, and I'm going to point to one thing that is pretty interesting. Call frequency limits. One of the driving forces in the proposed rule was emerging technology, text, emails, messaging, social networks. It doesn't cover this. The only item here under this proposed rules that limits the numerics, the number of calls that you can make or attempt, it only relates to telephone calls, not to emails, not to texts. I surmise that when the comment period goes forward, that's going to be an area that's going to expand. We're not going to be talking just about telephone calls. We're going to be talking about more. The proposed rule, it's a what I call a 771 rule. 7 attempted communications within a week's period. 7 tries. 7 attempted calls. If you talk with the person, you're done. You've had your one communication, you're done for a week. Now the difference is it relates to the particular debt. So if you are collecting, say if you have a debt collector who has multiple medical debts that are under different accounts, each one is a separate 7-call limit. There's one exception, that's student loans, and I haven't exactly figured this one out yet. In student loans, if they're being collected all under the same account number, so you could have multiple student loans all under the same account number, they're considered to be one for the purposes of the call limitation. Some exceptions to the rule, the 7 limitation, calls made to respond to a request for information from a consumer, calls made with the consumer's prior consent, and Jonathan, calls made to the attorney. So you get to have as many phone calls to you as you want. Here's the interesting interaction with West Virginia law and the Consumer Credit Protection Act. West Virginia, under one of the amendments that Sandy talked about, the 46A 2-125, put a limit on collection costs to 30 attempts within a week, or 10 actual communications. Little difference between the federal act and the state act is this: the federal act only applies to third-party collections. State act, third-party collections, and somebody also attempting to collect their own debt. So unless our number changes or the federal number changes, we're going to have a little difference here between the numerics that a third-party collection agency can call and what a creditor can call. I surmise you're going to see that 7 number increase, and I surmise that maybe, for debt collectors, our rule is going to be gone. We go through some of the other ones. Unintentional electronic communications, I'm not going to go too much into this. It's just another conduct rule, which basically says if you accidentally talk to somebody via text or email, there is kind of a bona fide error defense that the CFPB is considering. This is interesting. Every electronic communication must have an opt-out, not just initial, but every communication. You must give the consumer the ability to opt out. And you cannot say, well, give me some additional information. How can I call you? No, you can't do that. All you can do is give them an option. Don't charge them a fee. Don't ask for additional information. You can respond one time to say confirming the opt-out, but beyond that, you can't do it. There is some inconsistency, just so you know, in the rule, whether it's per debt or for life with that debt collector. I need to go more into the history of that to see which way they're going. I thought it was a little unclear from the rule itself. Media restrictions, and this applies to everything. Consumer says, I don't want you calling on this telephone number. I don't want you using this email. You're done. No more communications on that telephone number. No more communications on that email. You can reply once to say, okay. You can also reply if the consumer initiates a future communication on that communication medium. Time and place, I thought this was a little silly, but they put it in here. I didn't think about this, but the what you can't call at an inconvenient time or place now expands beyond just telephones. It's to electronic communications, text, messaging. I just assumed that was a given, but I guess I was wrong. Work email addresses. This one's important. No more. You cannot, and I don't think that was always in question before, whether you could do it or not. If the debt collector has reason to know that the email address they have is somebody's work address, you start off with the presumption you cannot use that as a method of contacting the consumer. There again are exceptions, which is if you've received prior consent or the debt collector receives an email from a work email from the consumer. Again, you've got the opt-out, so there can always opt out from that requirements. Conduct number 7, social media platforms. I know Facebook. I don't know anything else. My kids say there's much more. You can't use it except for in private messaging. Conduct proposal 8, decedents, estates. If somebody's passed away, mentioned earlier, the representative steps in the shoes of the consumer for the purposes of validation and for the purposes of disputing. Number 9, time-barred debts, Jonathan. Time-barred debts, first time ever, expressly prohibits, and I always thought this was the law anyway, so I'm a little confused, but expressly prohibits a collector from suing or threatening to sue on a debt if the debt collector knows or should have known that the statute of limitations has expired. Now, what's interesting, just so you know, when the advanced rule came out, one of the express disclosures the CFPB was looking at was one relating to debts beyond the statute of limitations. My understanding is later this month they're going to be sending out a survey to try to start doing more of the legwork behind to potentially create a proposed disclosure. That's important because the type of disclosure that the CFPB and the Federal Trade Commission has used in consent orders is not the same language that we have in West Virginia under our code in 46A-2-128F. So we'll have to see how that all combines and whether there are inconsistencies on that. We'll go through credit reporting. This one is important, and I've actually represented some consumers on this issue And what it is if a debt goes to a debt collector, and as opposed to contacting a consumer, what they do is they put it on their credit report. They report it. You can't do that anymore. That you cannot, a debt collector cannot place anything on a credit report or put a trade line until they've actually communicated. So tentative communications are not enough. Actual communicate with the consumer, then it can be reported. This may change a little bit because if you've got a 30 day or 10-day, well, 10-day in federal, but if you've got the ability to dispute the validity of the debt, 30 days in federal, dispute the validity of the debt, I could see that time period being expanded, that after the initial communication and right to dispute the debt, it goes, beyond that period. But right now, you got to wait till the validation notice goes out before they can report it. Other things, and then I'm going to get out, there's a prohibition on transfer of debts that are been paid, settled, discharged, bankruptcy. There's a limited contact message, which is just this. You leave a message with the third party. Hey, have this person call me. I put in the PowerPoint what information you can have and what you can't. I haven't gotten to this, but 4 key proposed disclosures. Look at the validation notice in the material I've given. CFPB, and I'm interested to see what Dr. Angus says about this, but I thought their proposed safe harbor disclosure is phenomenal. Instead of, if you want to dispute it, you check a box. You have a tear off at the end, kind of like a coupon that you rip off and you send back to the debt collector, but it's a very simplified form. And if you use it, you're in great shape. There's also some different languages notices too that we've outlined in the material. But again, look at the validation notice. I think that one, the only thing that may be a problem, state notices, according to this, have to be put on the back of the validation notice. Can't be on the front. That may run slightly into conflict with some of the state notices. Talk real fast, try to get it all in because it's a lot of information. So I'm around if anybody has questions afterwards.